just give us a minute more. Okay, so we are now live. Okay, great. Good afternoon, everyone. My name is Nipa. I work for Housing Court Answers as a hotline specialist, and today we're having a training on non-payment in housing court, and we are joined by Mr. Fernando Mancias Steinman. Mr. Fernando works for Bronx Legal Services, which is under the umbrella of New York's Legal Services, and we are grateful for him for this presentation. If you guys have questions, you can put it in the chat. Some of the questions we will be answering throughout the presentation if it's relevant to the topic at the moment. Otherwise, we will save them for the end of the presentation. So just if you have a question that comes up, just put it on the chat. We do not answer any personal or case-specific questions during this chat. It is a public training. So we don't want to, get into that. But yeah, if you have questions, just feel free to put it in there, and then we can go over it either during the training or at the end. And now I will hand it over to Mr. Fernando.
Hi, everyone. My name is Fernando. My pronouns are he, him. I've been an attorney at Bronx Legal Services for over 8 years. So most of my practice is in Bronx Housing Court. It's really lovely to sort of be joined by so many people across the city, both practitioners and also tenants. And I just want to say and acknowledge that I think as a community, our goal is all the same, to keep people safely housed in their homes. So please ask any questions along the way. Please feel free to throw them in the chat. And I'm sort of happy at the end to sort of stay on and answer questions as long as necessary. Before I begin, I do just want to say there is a lot of legalese, a lot of legal language in the presentation. And part of that is because tenants themselves will sort of have to confront the sort of legal language in housing court. And both will be expected to sort of understand what all of that language means, as confusing as it is. So what I have really tried to do is to include the legal language so that tenants are familiar with it, but also have tried to sort of break it down and explain what exactly those legal terms mean. So if at any point during this presentation you have questions about specific terms, by all means, please feel free to interrupt and let me know, because I want to make sure that it's very, very clear. I will also make sure that these materials are available to you after today's training. So today's training is about non-payment cases in housing court, but I do just want to give a very brief overview on housing court generally and the different types of cases, because I do think it's important for tenants to sort of recognize both what is a non-payment case and also what non-payment cases are not. So first and most importantly, I think people can be really shocked who are currently sort of experiencing eviction cases and recognizing that, like, housing court was not actually created to evict people. That was never the purpose. Housing court was originally created so that tenants could sue their landlords for conditions in the apartment. And over the years, it has turned into do essentially the complete opposite. Most cases in housing court are cases where landlords are trying to evict tenants. So if you walk into any of the courthouses in any of the 5 boroughs, most of the courtrooms are going to be dedicated for cases that are meant to evict tenants, not for cases where tenants are trying to get repairs done. And that's really, really significant, because I think it's a really big shift in power. And I think it's really important for tenants to recognize that together we can sort of all push against the system to sort of fight for repairs and also to try to make sure that people remain safely housed. So really importantly, in New York City, there is no right to self-eviction. What this means is that a landlord cannot just come and change the locks at any time and say, I want you out of the apartment for whatever reason. That's illegal, and that's an illegal eviction. If a landlord wants to evict a tenant from their apartment, they have to first begin a case in housing court. And that's really, really important, because I meet so many tenants at clinics or in trainings who tell me, I received this letter from my landlord and they said they're going to sort of kick me out or I have to be out by X date. And what I tell tenants all the time is if there has been no housing court case, then the eviction is not legal. And for what it's worth, most landlords know that, understand that, and do abide by that. And most people are not evicted unless there has actually been a housing court case. So I hope that that does, while eviction and eviction proceedings are always scary and they're always going to be stressful, I do think it provides a little bit of comfort to tenants to know that their landlord must go to housing court first. And housing court will also make sure the tenants are sort of protected in various different ways. Housing court cases are also summary proceedings. What this means is that housing court cases are actually meant to be processed fairly quickly. What we have seen currently is that with right to counsel and just the number of cases that are being commenced in housing court, it's taking much longer. But ideally, or initially when housing court cases were commenced, the idea was that they could be resolved within a couple of months. It is not unheard of currently to see cases that have been in housing court for 1, 2, 3, even 4 years. And that's an important part, right? Because I think that in a system where tenants are sort of fighting and struggling to stay in their home, we sort of want to delay the eviction as long as possible so that the tenant has the ability to get the resources and the help that they need to actually prevent the eviction. Tenants who go through housing court without an attorney are more likely to face eviction and face eviction faster than those tenants who don't have an attorney. Right now, it is really, really challenging to get an attorney. And I say that I say that because I think it's really important to acknowledge that we have set the expectation and what we have communicated to our community is that if you're in housing court, you're going to get a free attorney. And while that should be true, the reality is that there just aren't enough attorneys to provide assistance for all of the tenants who need the actual help. And so I think it's important to sort of make sure that we're sharing the information that we do have with our community, because the reality is that most tenants in housing court currently actually won't get a free attorney to assist them with their cases. Housing court essentially has three different types of cases. Eviction cases, so those are broken into non-payment cases and holdovers. Cases for repairs, those are known as HP cases. And then cases that are illegal lockout cases. So those are cases where the landlord changed the locks but never started a housing court case, and the tenant is now trying to get back in. And as we mentioned, today's focus is on non-payment cases. So in a non-payment case, pretty straightforward. The landlord is just seeking to collect rent that is owed. So if the landlord is trying to collect rent that is owed and the money is paid, then the case is essentially over. If the landlord is trying to evict a tenant for anything other than non-payment of rent, then the landlord is seeking to evict them under a holdover proceeding. And that may be many different types of reasons. Either the lease has expired, or there's an unauthorized pet in the apartment, or they're saying that the tenant of record doesn't live in the apartment. But that's really important because I have met many tenants who will also tell me, I don't know why my landlord is suing me. I don't owe rent. And when I will sort of go through the papers, oftentimes they're not suing you for rent. This isn't a non-payment case. This is a holdover case. They're suing you for something other than rent. So non-payment cases, essentially the landlord is seeking unpaid rent. If the unpaid rent is paid, then the case is over. An HP case is a case where a tenant or an occupant in an apartment is suing the landlord seeking repairs to the apartment or for harassment. And as I said earlier, that was essentially the purpose of housing court when it was first created. And then lastly, illegal lockouts. Again, those cases where the landlord has actually evicted the tenant without first starting a housing court case. So starting an eviction case. Before a landlord can begin a housing court case against a tenant, they have to send them the proper notices telling the tenant, if you don't pay your rent, I will begin a non-payment case against you in housing court. We call those notices predicate notices. So there are different types of notices depending on what type of case the landlord is bringing. So in a non-payment case, the landlord must send a 14-day rent demand. So the top of the document will say it's a 14-day rent demand. And what the document will essentially say is, tenant, you owe X amount of dollars. This is how much you owe each of the months. If you pay this money within 14 days, then there's nothing to worry about. But if you don't pay this money in 14 days, then the landlord will begin an eviction case against you. This is really important because this is the very first paper, aside from like a regular rent bill that goes monthly to the tenant, that the tenant will actually receive. And this is sort of when the stress begins for the tenant. I will meet many tenants who will get this notice and tell me, I have to be out of my apartment in 14 days, or the landlord said that they're going to evict me in 14 days if I don't pay this. And that's really, really important to make sure that whenever a tenant is sort of telling you they received a notice, that you're looking at the notice specifically so that you understand what it is. And if on top it says it's a 14-day rent demand, then you know the eviction's not going to happen immediately. Rather, what it means is that if the money isn't paid within 14 days, the landlord then has to begin the housing court case.
Just a question I think may be relevant. What if the landlord does not live in New York? I filed paperwork with HPD that I am withholding because of repairs.
So the I guess I'll sort of address the second part first. If you are withholding rent because of repairs, the landlord can still start the case against you because rent hasn't been paid. So technically, rent is owed. You do and you should raise it as a defense to say, I am not paying my rent because the landlord hasn't done repairs. And it may be a defense to the case, but the landlord can still start the case against you because technically rent is still owed. If the landlord doesn't live in New York State, I think as long as they're making sure that they're getting the papers to you, I think that that's fine. They don't have to live in New York State. And oftentimes a landlord really isn't a person, it's a business. And then there are people who managing agents who sort of operate the business.
And then somebody just wanted a clarification. Who sends the 14-day run demand notice? The landlord or the court?
The landlord sends the 14-day rent demand.
And if a landlord sends a 14-day rent demand and the tenant doesn't pay, does the landlord then have to send a notice? Okay. Oh, no. Okay. Sorry. There's a wrong question. Is there authority to point in the situation where the landlord has an open holdover case and then initiate a non-payment case at the same time?
I will, yes. So if there is a holdover case, so the landlord is suing you for something other than rent, and they then begin a non-payment case, then the holdover case is over, or it should be over. So you should let the court know. And the reason that is because in a holdover case, the landlord is saying that the landlord-tenant relationship has ended because of whatever reason they're claiming. In a non-payment case, there has to be a landlord-tenant relationship because if there is no relationship, then you are not required to pay rent. So there has to be essentially a contract, which is the lease. So I'll say this because it's really important. They can They cannot start a non-payment case after a holdover, but they can do the opposite. So if they have a non-payment case first and then they start the holdover, that is okay. But they cannot do the holdover first and then the non-payment case. Once they start the non-payment case after the holdover, it should basically undo the holdover case.
Okay. And there's other couple of questions I just want to reiterate to everyone that some of these questions will be answered throughout the training. And if it's not, I'll just go back in. So if you posted a question and hasn't been answered yet, it's probably because it's going to come up later on. But if it doesn't, then I'll ask Fernando.
So this is an example of what a 14 days notice looks like. And I removed some of the personal information about the tenants. But this was sent to the tenant and the 14-day notice, actually, the other thing I should say is it has to be a written notice. So before 2019, there were different laws that said that you could say it, you could have the landlord go or a worker for the landlord go to your apartment, tell you owed rent. After 2019, the law changed. It has to be a written notice and it has to be a 14-day notice. So this notice says, for instance, that the tenant here allegedly owes over $10,000. They broke it out here by each month between February 2023 and October 2022. But the really important paragraph here on the bottom is paragraph 3, which says that if the tenant doesn't pay the $10,000, and this is why people get confused with the notice all the time, because it says you must surrender possession of the apartment within 14 days that you receive this notice, or the landlord will commence summary proceedings to recover possession. So there's a lot of legal language in there, and the average tenant might see this, and I understand and recognize why the feeling is the landlord is telling me I have to leave my apartment within 14 days. What the landlord is actually saying is, if you don't leave the apartment within 14 days, or if you don't pay the money within 14 days, then we will begin a housing court case against you. And this is why, and I'll repeat it over and over again, especially to the tenants, it's really important to know if there has not been a housing court case first, you cannot legally be evicted. So if a tenant receives this notice and they cannot pay the money within 14 days, and most tenants can't, and that's okay, just know the next step is you're going to get official housing court papers. And I'll show you what those papers look like so that you're familiarized in case you sort of see them in the mail. But any questions about the rent demand at the 14 days notice?
I think it'll just come up in a little bit, but just for clarification, if a landlord sends a 14-day rent demand notice and the tenant doesn't pay, does the landlord then have to send a notice of petition and petition after the rent demand letter?
Yes, the landlord does have to send the notice of petition, and that's the next slide. But the other thing I will say is I have met tenants who have actually paid the money within the 14 days, and the landlord will still begin the case against them. It's a defense, and the tenant should raise that. But the next step after the 14 days notice is the notice of petition and petition. So if the tenant hasn't paid the money within the 14 days or hasn't left the apartment within the 14 days, then the landlord must send the tenant what's called a notice of petition and petition. And this is essentially the official lawsuit against the tenant for the non-payment of rent. There are very specific things that the petition must include. Some of those include that the parties have a lease. As I mentioned again, if there is no lease between the parties, then the tenant doesn't legally owe rent. So there has to be a current valid lease between the parties for the non-payment of rent. The petition should also state whether or not the apartment is rent stabilized or has some other special type of legal protections or legal regulations. So there might be tenants on the training today who live in a Mitchell Lama building or live in NYCHA housing. So that should be clear in the petition what type of apartment it is. If the tenant also receives some type of assistance for their rent, that should also be included in the petition, because the agencies who help with rent should know that the landlord is trying to evict you. And if there's an issue with payments of, that the agency has to make, then they should make them. Or if you end up being evicted, then the agency also has to know that so that they can stop payments. So some of those, for instance, are tenants who have a Section 8 voucher administered by NYCHA or HPD or DHCR or CBR. And briefly in a holdover, it also has to state what type of holdover case it is. During the pandemic, so before the pandemic, housing court was entirely done on paper. So everything was paper notices. The entire court system were paper files. Nothing was online. That changed during the pandemic. And now the landlords essentially have to sort of file everything online. The online system is known as NICEF. So if you're wondering, is there a case against me, or I got the 14-day notice, but I don't know if the landlord started the housing court case after, you can use NICEF to sort of search information. I'll show you what that looks like in a few slides, but just keep that in mind because it is really important to know because you should be able to find that information. There is one small exception. If you live in a smaller building, so like a private family home, and the landlord is beginning this case without an attorney, those files may not be online immediately. But other than that, if there is an attorney, those documents should be filed on NICEF. So this is what a notice of petition looks like. And you'll notice on the top right-hand corner, it says notice of non-payment petition. And as I said, it's going to have, the notice of petition is really important because it has really critical information for tenants. So if tenants need to request a reasonable accommodation, or if tenants need to they're unable to go to housing court because they have a disability or they have mobility issues, or if they need the document in some other language, there's information on the notice of petition for the tenant. It has phone numbers where they can call. So this is what the document looks like. On the top right-hand corner, again, it'll say notice of non-payment petition.
Okay, so there were some questions that came up. Um, somebody, sorry, I think it just got lost. But somebody says, what if you are having issues with the mail and never notice? What can you do?
That is a really big issue. If you have, there might be different issues with the mail, but if the landlord, so for instance, if you have a broken mailbox, I would report that to the landlord immediately, because the landlord should know that if they need to sort of fix the mailbox if they're going to sue you in housing court. What we have seen is, and we'll get to this a little sort of down the road in the presentation, but if you don't get the documents and you never go to housing court because you just didn't know about it, the landlord may automatically win. And if the landlord automatically wins, they may be able to move forward with an eviction. If that happens, you may get a notice of eviction on your door from the marshal that says, we are going to evict you within 14 days. If you get that notice and you had never received the court papers, it's important to go to housing court immediately, file what's called an order to show cause to try to put the eviction on hold, and explain, I never received court papers. Or if your mailbox does work and you just never receive these documents, and you then receive some type of notice from the court saying, your court date or whatever it is and then you want to sort of raise it as a defense. And again, we'll go into that in a second, but just to briefly answer your question now.
Yeah. There is a question, a portion of it is going to be answered, but it's what happens more specifically if landlord sues for non-payment, but there's no lease? Can clients ask for discontinuance? What if the client does not want to sign the lease?
Yes, if there is no lease in effect, then they should ask the court to discontinue the case. If the tenant doesn't want to sign the lease, right, then there would be no lease. Then the landlord would have to start a holdover case, if they want to evict you. But if the landlord wants the back rent and there is a lease in effect, then they would start the non-payment case.
Um, and then I think one question that always I think also comes up is that people get confused when they get the notice of petition and they see something that says e-filing. If you can clarify that part, what that actually means for the tenant, because I think in terms of like answering, we get those questions a lot.
Sure. Tenants can absolutely, as I mentioned earlier, documents are now on NICEF, and NICEF is the electronic filing system. If tenants want to participate in it, they absolutely can, and they can submit their own papers on the e-filing system. In my experience, I don't think I've never seen a tenant submit the documents online on their own. Most tenants go to housing court and submit paperwork with the clerk, and then the court is supposed to upload those documents to the system. So tenants do not have to participate in the e-filing system. And if tenants choose not to participate in the e-filing system, then the landlord must still send them hard copies of the documents. If the tenant participates in the e-filing system, then what they're also saying is you don't have to send us papers by mail or hard copies of papers.
And I think this is a general question. What if happens if a tenant receives a notice of non-payment dated beginning of March, but the client did not receive the mail in the beginning of April? The envelope has the mail date for April.
Uh, so I think I just want to clarify, what I'm understanding is that maybe the date on the notice of petition is a different date than the actual mailing. So whenever a landlord mails out a document to the tenant, like for instance, mailing the notice of petition and petition, they also have to include or they have to file with the court a statement that says how they actually delivered the papers to the tenant. So they might say we gave them to the tenant in person. They might say we mailed them to them. So if you want, you can review that on NICEF. And if you see that the information isn't correct or isn't accurate, then you could raise it as a defense when you're in court. Any other questions, Nipa?
I think the other questions will be answered, so we can move on for now. Yeah.
So as I mentioned, the notice of petition has some important information. So this is some of like the contact information that you may need if you need to request language access assistance or a reasonable accommodation. And then the petition is the document that actually has the information that we were talking about what why the landlord is saying that they're suing you. So in this case, for instance, it says that there is a lease between the parties and that the rent is $1,598.65. It also says that the apartment is a rent stabilized apartment, and it says that the tenant it also says how much is owed. So here it says that the tenant owes almost $3,000. So once the tenant receives the notice of petition and petition, the court does not automatically assign a court date. So there is nothing in those papers that tell you you must come to court on X date. This is true in a non-payment case. In a holdover case, they do actually have to indicate when you go to court, but it is not true in a non-payment case. So the only way to get a court date in a non-payment case is the tenant has to go to the clerk's office at the housing court within 10 days to file an answer. So they'll get the document and they'll say, I don't agree, I don't owe this much money, I made these rent payments, or they'll say, I owe this money, but I haven't been paying my rent because there are conditions in the apartment. And so technically you have to do that within 10 days. If you don't do it within 10 days, then the landlord can then pursue what's called a default judgment, which essentially means the tenant never answered and we want to automatically win the case. The reality is that landlords don't do it immediately after 10 days. It's usually a couple of months, so that if the tenant hasn't gone to court in a few months, then they'll eventually do it. But if you get the notice of petition and petition, you should go to the courthouse within 10 days. But if not, you want to go in as soon as possible. I have a client who recently sort of reached out to us for assistance. She is she is deaf and she needs a sign language interpreter. She has a system on her phone that sort of connects her with an interpreter on her end. So, going to housing court was going to be really challenging for her because there wasn't likely to be an interpreter on site immediately, but she was able to call sort of the language access number. They connected her with someone and she was able to file an answer over the phone. So if there is some reason that you cannot actually make it to housing court, you have a mobility issue or some type of disability, then you can call the language helpline or the ADA helpline so that you can file your answer over the phone. But for most tenants, you're going to be filing the answer in person with the clerk. Essentially, what the answer means is it's your response to the lawsuit to say whether you agree with things or whether you disagree with things. For tenants, the way it essentially works is you'll stand in line at a window. Once you get to the clerk, they'll ask you for your information. You need to show identification to show that you're who you say you are and that you live at the address for the apartment. And they will ask you a few questions and you will give your responses orally, and the clerk will just sort of put your answers on the document for you. So most tenants do not write their own answers. Most tenants will go to the clerk, tell the clerk what their defenses are, and the clerk will mark it down. That also means that sometimes clerks make mistakes, and clerks may not include some defenses that tenants say that they had. So if you get the paper, and I'll show you what the answer looks like, and it looks like either the clerk made a mistake or didn't include some information that you said, you're going to want to raise that either with the clerk or on your first court date. In an answer, you sort of want to raise whatever possible defenses you have. So we talked about earlier about not getting court papers. So you should definitely raise it as an answer in your answer. Say I didn't receive them, or my mailbox has been broken, or my landlord hasn't fixed my mailbox, so I never received these documents. If the address on the papers is wrong, or if they included the wrong name, you should also raise that. If you paid rent, even if you only paid a portion of the rent that they're seeking or the arrears that they're seeking, you should absolutely raise that. If the landlord is seeking more rent than your lease says your rent is, you should include that. Or if it's the landlord is seeking rent that was owed for the last 2 or 3 years, you should certainly raise that too. And if there are conditions in the apartment, and I tell clients this all the time, it doesn't matter how big or small those conditions are, you absolutely want to raise it as a defense. I meet many clients along the way who say, I feel like I can't ask for repairs because I owe rent and it's not fair. Or they'll say, the number of times where I've met people who sort of don't even consider mice or roaches as conditions because they've just been so used to them can be really upsetting, right? They are conditions. The landlord does have an obligation to fix that. So it doesn't matter if it's a leaking ceiling, or it's just that the paint that the apartment needs to be painted again because it hasn't been painted in several years. Those are all conditions that the landlord has to fix. And you should absolutely raise that in your answers in a non-payment case. If they're, sorry, yes, go ahead, Nipa.
Oh yeah, so somebody had a question they wanted a clarification on. Is notice of petition and petition two different documents?
Yes, you will get the documents together because they sort of go hand in hand, but they are two different documents. The notice of petition essentially tries to explain to you sort of what the housing court case is about, or what a housing court case is, and it has information about numbers you can call if you need assistance. The petition is a document that is like technically the actual lawsuit. So it'll there say this is how much is owed, you have a lease or you don't have a lease, and this is the type of apartment it is.
Okay. And then some people were asking, what is stale rent and is there a limit?
Yes. So in housing court, there is a defense for low-income families or low-income tenants. And the defense is essentially the landlord waited too long to begin a case. And the idea behind it is that if a landlord knows or should know that you are a low-income person, they might purposely be waiting a really, really, really long time to begin a case so that the arrears are so high, it would be nearly impossible for you to pay them. And if because you're a low income person, and if so, if you're unable to pay them, right, then you're going to be evicted. So that's sort of the idea behind it. There's no hard rule for it. So judges have interpreted in many different ways. Some judges have said if it's more than 6 months, that's too old. Other judges have said if it's more than a year, it's too old. Other judges have said if it's more than 2 years, it's too old. And so that's what it is. But what's really important to know is that money doesn't just go away. You still owe that money. The argument is just that you shouldn't be evicted for that money. So the landlord may still be able to collect it from you, but if you cannot pay that portion of the money, then you shouldn't be evicted for it.
Yeah, I'm seeing a couple of questions about holdovers. Just I want to point out that this training is about non-payment. If we have time at the end and Mr. Fernando is able to, we will answer some questions about holdovers, but the focus of the training is specifically about non-payment. Um, there is a question that said, it's a little personal, but it's also relevant, I think, to the accommodation. My
Mhm.
uncle is the tenant. I answered for him at the courthouse within 10 days. He needs an accommodation for his court date because he's wheelchair bound. Will this affect this request?
Um, so it's great that you were able to file an answer. Technically, though, if your uncle is the tenant of record, and if you are not the tenant of record, then your uncle does have to provide an answer. So I would probably try to encourage your uncle to call the number that is listed here and tell them that he can't appear in court. He should file the answer over the phone, and they should also be able to provide him with a court appearance where he doesn't have to go in person. So they may provide him with a link or a phone number that he can call in so that he can handle his court case that way. And sometimes if there are tenants who cannot appear in court due to mobility issues, the court can also assign what's called a guardian ad litem. And the guardian ad litem in a housing court is just a person who sort of helps a tenant who needs some type of special assistance because of mobility issues or they're elderly or whatever else it might be. So that is also something you can request.
Okay. Should the landlord restart the case seeing the tenant did not receive the eviction notice or court paper to start an eviction notice?
Um, if so, I think I understand the question to mean that if the tenant says that they never received the notice of petition and petition and only learned about the case because they received the notice of eviction, then the landlord doesn't necessarily have to begin the case all over again. The the judge might allow the tenant to essentially undo the undo the default judgment and just begin the case all over again. But if the tenant wants to push really hard and says, I never received this case should be over, and they're successful there, then yes, the landlord would have to begin the case all over again.
Can a landlord bring a non-payment case if tenant hasn't paid rent, but they are month to month and don't have a lease?
Yes, because month to month is a type of tenancy. So most tenants will have a written lease where it's very clear, the lease begins January and it ends December. But in month to month tenancies, it's essentially a handshake between two people. And if the tenant continues to pay rent and the landlord is accepting the rent, then there is essentially a handshake to extend the lease for another month. If the landlord is suing the tenant in housing court for the non-payment of rent, and they're saying that they're no longer a month-to-month tenant, then the tenant should be able to ask that the case be over because there's no lease or there's no agreement to pay the rent.
And I think just a clarification, somebody said you did say I don't have a lease, I'm not liable to pay rent, just in case I do have escrow.
Uh, I'm not entirely sure I understand what that means, but what I will say, at least I'm not sure on the second part what you mean about the escrowed money, but what I will say about the first part is if there is not a lease agreement in whatever shape form that is, so that might be an actual written lease, that might be the month-to-month agreement, but if there is not a lease agreement between a landlord and a tenant, then there is no obligation to pay rent, which means the landlord can't sue you for non-payment of rent. If the landlord is suing you for non-payment of rent, then they are acknowledging that there is a lease agreement between them and the tenant.
And then, do those experiencing domestic violence have any special protections in housing court?
Yes. Um, in housing court, it's a little frustrating and it's a little complicated, I think, for survivors of domestic violence, because on the one hand, um, I think what I've seen in my experience is that money has been taken from them or it's not a safe place to live in. And so on the one hand, it's both, I shouldn't have to pay this rent, but then it can also be really complicated if they have nowhere else to go. So there are protections in that if you are the tenant of record and you are a victim of abuse, that you can break your lease before it is over. So that is a protection. So if your lease ends in August and you're sort of experiencing violence now, you decide to leave, your landlord you should be allowed to end your agreement early. But all that also means that you have to leave the apartment. So if you stay in the apartment, you have fewer protections because you're remaining in the apartment. So there are more protections for victims or survivors who leave the apartment than there is for victims or survivors who remain in the apartment.
When the client has a non-payment case and the client paid off the arrears and has a zero balance, is it the landlord's responsibility to dismiss the case or the tenant?
Technically, I guess it should be the landlord's obligation because it's the landlord who started the case, so they can withdraw or end the case whenever they want to. Um, but I would say that, like, I don't know that most landlords are very good at that, so the tenant should certainly advocate if they have paid all of the arrears that are owed, then they should ask for the case to be over.
What are waivable versus non-waivable answers, and how does this distinction change if the reply is in form of motion to dismiss instead of an answer?
Uh, what I think they're asking is sort of a little bit more legal, but I think they're essentially saying like asking like what type of defenses must they raise or what type of defenses they can sort of not raise in an answer or sorry, whenever they file an answer. So some of those defenses would include if you did not receive the court papers, you should absolutely and you must raise that in your answer. Um, if, however, there are conditions in the apartment, that is a defense that you don't necessarily have to raise, and you may choose not to raise it if you don't want to. But the ones that you sort of must raise are really around the idea of like wrong name, or they should have named somebody else, or I didn't receive the papers.
Okay. So those are the questions for now.
Okay.
Thank you.
Oh, sure. So this is an example of what an answer looks like. So this is not something that the tenant prepared on their own, but this is sort of a sample form that the clerk uses, and they will fill it out based on whatever the tenant has told them about their defenses. And so just as an example, this is one of our clients who we recently saw. They filed their answer, it says answer in person, but they actually called in and they filed their answer on April 5th, and their first court date is not until July 1st. So that is just like a very clear indicator to you of how swamped housing court is. That is the experience in the Bronx, and I know it's happening across the boroughs. So housing court case, I mentioned at the beginning, they were summary proceedings. The goal was sort of for them to sort of be resolved very quickly within a couple of months. The reality is it's taking a really, really long time. And for most tenants, I hope that provides some type of comfort because I meet so many people who, the minute they get any document from housing court, get really stressed, and understandably so, right? The thought of losing your home and being evicted is very overwhelming, very stressful, especially when you know that it's gonna be a fight to get an attorney or to get the help that you need. But I do hope that there is some comfort in knowing that currently housing court cases are taking a really long time to resolve for many different reasons. And so when people tell me, I want to make sure I'm not going to get evicted tomorrow or in a week, the reality is for most people, it's not going to happen ever. And for most people, it certainly is not going to happen for many, 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 many months. And there are resources and a community, and we're all here to sort of help each other resolve your cases so that you can stay safely housed. But essentially, this is what an answer will look like. And I do just want to bring up something very quickly so that you sort of understand what happens on the first court date. So if you look on the very bottom, it says court date July 1st, 2024 at 9:30, and then it says intake part 1, room to be determined. Currently, what is happening in housing court is when a tenant files an answer and they get their first court date, the first court date is not actually in person, it's virtual, meaning that the tenant has to either call in or appear on Microsoft Teams, so on the internet. And the only thing that happens on that first court appearance is the tenant is asked, do you want legal assistance with your case? If they say yes, they will be connected with the legal services provider assigned to that day. And if they say no, then they won't. And then there is another court date after that. So that court date, so if this person, goes on July 1st, the only thing they're gonna ask them is, do you want an attorney? They'll say yes. And then the next court date won't be likely until August or September. So again, housing court is significantly delayed, and just keep that in mind. Okay. I mentioned earlier that housing court files are now available online. They're available electronically. So this is the easiest way to do it is just to search NICEF on the internet, and it'll take you to the webpage. But this is what it will look like. You do not need an account to look up documents, which is a good thing because it means you have access to the documents, but it can also be a bad thing because that means that there's like a lot of very personal information about a lot of people available online. And, as attorneys, as practitioners, as advocates, we also sort of really want to be very mindful about the information that we're including, because it will be uploaded online unless there's some special type of protection, but keep that in mind. So you'll go to the NICEF. On the left-hand side, there under account, it says search as guest. You'll click that. Then you can click the name tab on the top and you'll put in someone's first name and last name, click search. Depending on how common the name is, it might pull up 50 results. If the name is not super common, it may pull up, 4 or 3 results. Just a small caveat, many landlords will misspell tenants' names. So if the name is different than what you're searching, you won't find it immediately. So, for instance, if the tenant's last name is Garcia, which is Garcia, but the landlord sort of switches the first R and A, then you won't find it under that name. But generally speaking, most names are correct and you should be able to find it if you. So again, this is a helpful tool if you receive the 14-day rent demand and you're really nervous about whether or not the landlord has started a case against you, you can check online to see whether or not the case has commenced. Or if you're working with the tenant and maybe the tenant says, I don't have these court papers, or I went to court on April 1st and I don't know what happened, you should be able to find the document online. Yes, Nipa.
So somebody asked a question. Once a court date is decided upon, does the tenant continue to pay what they can, even if not in full?
Yes, and I think I would say that generally speaking, tenants should continue to try to pay their rent whenever they can, because it's going to be really important when they're seeking assistance for rental arrears that they can show that they're trying to make payments ongoing. However, if the landlord says, the tenant owes X amount of money and you disagree with that because you know that there are payments that you have made, then I might hold the money, because there might be some type of issue with your payments not getting to the landlord for whatever reason. So if it appears that the landlord is receiving your rent payments, then yes, continue to pay them. If you think there might be an issue with the delivery of your payments, then I would probably hold off on them and purchase money orders. And if you're going to purchase money orders, I always recommend getting them from the post office as opposed to sort of other places. So, but yes.
A general question. How long does sorry, typically, how long does a non-payment case take in terms of processing?
In terms of processing, so they were technically supposed to give court dates within 5 days. But as you can tell, it's taking months at this point. It's so right now there were a whole bunch of cases that were essentially put on hold because of pandemic protections. So my office, for instance, has cases from 2019, 2020. That seems is going to be a little less true moving forward because cases that are started now, I think, are looking at probably almost to a year. They last a really, really long time for many reasons.
Somebody just made a comment that typically we have not seen cases updated in real time on nice stuff. And then also that in Manhattan, in their experience and for Manhattan Housing Court, people have to go in person for the first time.
Okay. So yep, so the first part about night courts have to sort of upload documents. I think there's a big push for court systems to be better at uploading documents and to do it faster. And so we have I mentioned I work in the Bronx, so a lot of my experience with the Bronx Housing Court, I do think that Bronx Housing Court is getting much better at uploading documents online. But yes, it is true that the court may not be uploading all documents timely. And to the other part, I will take back that statement then, at least in Bronx, the first housing court is virtual. It will depend, I guess, if you're in one of the other boroughs. But if there's any reason, if you have a disability or mobility issue that you cannot make it to court, you should call the number in the hotline to request a virtual court appearance or to request some type of assistance.
How does a tenant petition the court to close a case once the tenant can prove that all of the rent has been paid?
If there is a court date, then at the court date, then they would ask the court to end the case. If there is no future court date, then they can file what's called an order to show cause, asking the court to end the case because all money has been paid.
Is it a good thing to have a HP and a housing court case together?
Yes and no. So it can be helpful in that if there is an HP, then there might be violations, like official violations from the city indicating that there are repairs in need or there are conditions in need of repairs. And you might be able to use the HP case for leverage in the housing court case. So in that way, it's good. It is not always going to be the best. And sorry, the other thing about an HB case is the judge can actually order them to sort of do the repairs. So that might all be very helpful. It may not be helpful in that they will be operating on two very different timelines. So you might be in court on the non-payment today, and maybe your next court date is in a month. But with the HP case, if you're in court today, the next appearance may not be for another 2 months. So depending on how backed up they are. And because there are fewer HP parts, their adjournments are much longer. The other way in which it's not helpful is that the minute you raise conditions in the HP case, you are not allowed to sort of raise them in the non-payment case, which can be really challenging. Because if you're saying, I shouldn't pay this money because the conditions haven't been fixed in my apartment, the judge might be really dismissive of that and say, well, that's what you have an HP for. Deal with that in the HP case, not in this non-payment case. So I think it depends.
Okay, we can move on.
Okay. So again, I guess the caveat here is that the first appearance will be virtual if you're in the Bronx, but if you're in one of the other boroughs, it may actually be in person. And the purpose of that first court appearance, again, is to check in to see whether or not you want an attorney. And if you do, then they'll connect you with the legal services provider. What I will tell people a lot is it can be, and this is very frustrating for many tenants across the city because I think there is this messaging that tenants have the right to an attorney. And again, while that should be true, the reality is that there just aren't enough attorneys to help all of the tenants who are currently in housing court. So if you want legal assistance, it is very important on that first court date to say that you want a free attorney. If you if you say you don't want one, and then you decide in a month or two when things feel more complicated with your housing court case that you want an attorney, it will be very, very, very hard to get one. And the reason that is because most legal services providers are taking clients directly from housing court. And this is the first court appearance is really meant to be that opportunity to connect people with tenants. So if you want an attorney, I would encourage you or your family, your friends, or whoever is going through housing court case to request one on that very first court appearance. Because if you try to get one at any other point in the process, unfortunately, the likelihood of you getting one is going to be very, very, very slim. I mentioned earlier that if the tenant, never received the court papers and they only learned about this, or they never received the court papers, or they received the court papers and never filed an answer, then the landlord may move for what's called the default judgment. And a default judgment essentially means that the landlord has automatically won the case without having to prove anything and can move forward with an eviction. If a tenant doesn't appear for a court appearance, that can also lead to a default judgment. So if the tenant missed a court appearance for, whatever reason, they're going to want to go back to court as soon as possible to sort of undo the default judgment. And you'll want to explain, hopefully there's a very good reason for you missing the court date, some type of emergency, a medical emergency, or whatever else happened, and you'll want to explain that in your court papers. So how are housing court or how are non-payment cases or eviction cases resolved? In some circumstances, they may be dismissed. So, based on some type of legal defense. So we talked about earlier about, can a tenant get their case kicked or dismissed because they said that they never received their papers? The short answer is yes. The long answer is, unfortunately, in my experience, most tenants have a really challenging time getting cases dismissed when they don't have an attorney. It's unfair, it's not right, it's absolutely unjust. But the reality is that I think it can be much harder for tenants who are litigating cases on their own to get cases dismissed. That doesn't mean you shouldn't try. If you're operating a housing court case without an attorney, you absolutely should. But the majority of cases will be resolved by a court agreement. Court agreements are also called stipulations of settlement. And a stipulation of settlement is essentially an agreement between the parties to resolve the cases. In non-payment cases, there are essentially two ways that a case can be settled. The case can be settled with a judgment, or the case can be settled without a judgment. Judgment is a very sort of specific legal term, and I think that and it can be confusing. It's confusing for attorneys to explain to tenants, and it can be confusing for tenants to understand, and the court just assumes that everyone knows what a judgment is. The way I sort of like to explain settling a case without a judgment is essentially like a handshake. The landlord and the tenant agree, this is how much money is owed. The tenant will pay the money by X date. If that money is not paid by that date, the tenant cannot be evicted. The landlord has to bring the case back to court and then ask the judge for permission to evict the tenant. So if you are in housing court and you are litigating a case on your own, you want to try to settle the case without a judgment. Because if you cannot meet the payment deadline, there is no automatic eviction. Settling a case with a judgment is the complete opposite. A judgment means that you owe the money and that you are giving the landlord permission to begin the process, to begin the eviction if the money isn't paid by a certain deadline. So in a judgment, essentially what the tenant is saying, I agree that my eviction will be put on hold until X date for me to pay the arrears. If the arrears are not paid by that date, then I can get evicted. The landlord doesn't have to do anything else. They don't have to come back to housing court. So if we're thinking about the two types of settlements, right, with a judgment or without a judgment or with a judgment, tenants generally prefer settling without a judgment because, again, it means that they're further away from an eviction. Landlords will almost always want to settle the case with a judgment. So then the question becomes, how do landlords attorneys sort of trick tenants in housing court? What I will see in my experience is tenant comes up to the landlord says, this is how much is owed. The tenant will say, I agree, I owe that money. I'm working with HRA, I just want time. The landlord will say, no problem. I'll give you 90 days to pay the money. Sign this agreement, you have 90 days, and then if you don't pay the money within 90 days, come back to housing court. The landlord is going to be willing to give you more time to pay the rental arrears if you give them a judgment. And the reason they're willing to do that is because currently it can take a really long time to get the paperwork in place to actually get the judgment, which is what allows the landlord to move forward with the eviction. So if you're trying to settle the case without a judgment, right, where you want to make sure, like, if I don't pay the money by that date, I'm not going to get evicted right after that, and you're settling it without a judgment, then you might get less time. So the landlord may say, I'll give you 90 days with a judgment, but if you're telling me you don't want a judgment, I'm only going to give you 30 days. So if you're looking at 30 days versus 90 days, I think most people would prefer 90 days. But as I said, after the 30 days, the landlord can't automatically move forward with an eviction. They have to bring the case back to court. And as I've told you, housing court right now is very, very, very backed up. So by the time the landlord brings the case back to court, by the time you and the landlord, and then when the comes back to court, you and the landlord can reach another agreement to say, fine, now you get the judgment, and now I want 60 days or 90 days. You will still get yourself more time, like big picture wise, if you start without a judgment. Because if it still takes 3 months for the landlord to get their judgment, and you had already settled with 30 days, you're now looking at 90 plus 30 days, so 120 days. So even though it seems like you're getting more time by getting the judgment in 90 days, the reality is you're more likely to get more time down the road if you start without a judgment.
I think somebody had a question they wanted to clarify.
Sure.
Um, is that through a per stipulation agreement without a judgment, that is?
Yes, so a stipulation is just means agreement. That's all that means. So all agreements are stipulations. So yes, it's a stipulation with a judgment or a stipulation without a judgment, with a judgment, without a judgment.
I have seen landlords put in the stipulation that they can evict the tenant by a certain date if they don't pay the arrears, even though there is no judgment. Is this legal?
No. So if the document says that they can evict someone, then it usually means that there is a judgment. So the easiest way to tell, if you're looking at a stipulation and you're trying to figure out sort of is there going to be an eviction or not, is it'll tell you. So if the tenant doesn't pay, then if it says that the case can be restored, that means that the landlord has to bring the case back to housing court, which means there's no judgment. But if the document says that your eviction is put on hold and that, all holds will end if the money isn't paid, then that's with a judgment.
Um, what leverage does tenants have for a settlement without judgment and or negotiating the claimed amount down outside of overcharge repairs?
Great question. So the if the parties cannot reach an agreement, then the case will be sent out to trial. And I will, again, I practice in the Bronx, so I can sort of speak to what happens in the Bronx. But if the tenant and the landlord don't reach an agreement, you can always ask for another court date. And you can say, I just want another court date because they haven't done repairs in my apartment or whatever other reason. And the court might do that. And like I said, because housing court is so backed up right now, the next court appearance, I think so today's April, the court recently was giving out court dates in end of May or June. After that, if the parties still don't reach an agreement, then they can say we want to go out to trial. In the Bronx, when that happens, it can take a while to get into the trial part. And the first court appearance in the trial part is not an actual trial. It's what's called a pre-trial, which is where the judge again tries to see if the parties can reach a resolution. So the leverage, and I think it's really important because there's always leverage. And I tell the attorneys that I supervise all the time, you always have leverage. You have to figure out what it is, but there is always leverage. So you asking for an adjournment or to go to the trial part is going to delay the case even longer. So that you can tell the attorney, I'm willing to settle now without a judgment, right? And you get the clock ticking, or You adjourn the case only to then settle down the road, which again is going to give you more time. And so that's sort of the leverage that I think you're going to find in housing court on why you should get a judgment or without a judgment.
What is the difference between judgment put in a stipulation and a court-ordered judgment? Sometimes I hear a judgment was given by a judge.
Yes. So a judgment and a stipulation means that the tenant themselves agreed to it. So they agreed, this is how much money I owe, and I'm willing to agree to the judgment. A judgment issued in a court order or decision means that the tenant doesn't necessarily agree to it, but based on whatever information was presented to the judge believes that there's enough information there for them to issue the judgment. So that's the difference. So on this slide, right, the other way that a case might be resolved is a decision after a trial or a default judgment.
Sorry. Um, the landlord started a non-payment case against, but repairs were not being I'm assuming they meant made even after we did a stipulation. How do you request an abatement?
So very important. You can, if once you settle a case, so once you agree this is how much money is owed, you are saying you're resolving the abatement claim. Because an abatement is essentially you saying, my rent is $1,000, but because of the conditions in the apartment, I'm not getting the full value of my apartment. So my rent should be lowered to 900 or 800 for whatever month until the conditions are fixed. So that's what an abatement is. So the minute that you settle a case, you are also settling an abatement claim because you are acknowledging this is how much is owed. You can request an abatement for any rent in the future. So let's say I settle the case through March, the landlord didn't do the repairs. I come back, the repairs are still here. I can ask for an abatement for April if I've already settled the case, but I can't, you'd have to go back and undo the agreement, which is going to be much harder to do. So do not settle the case if you do not agree with the number for whatever reason.
Is the first adjournment request an absolute right?
Uh, it's not an absolute right, but I do think that there is a courtesy that on the first court appearance, there is an adjournment.
And then in a rent stabilized apartment, what if the tenant did not sign the lease from the landlord?
Um, Tenants in rent stabilized apartments basically have to sign renewal lease. It's not really a defense to say I don't owe the rent because I didn't sign the renewal lease. However, if you did not sign the renewal lease because the rent in it was wrong or the calculation was wrong, then that may be a defense. The other thing I'll say is that if you have not signed the lease, a renewal lease, the landlord cannot charge you for the increased rent. They can only charge you for whatever lease you have signed. Um, yeah.
What if the landlord asks you to acknowledge that you received the court paper and he will reduce the rent? Is that legal?
Um, eh, I guess it could be like a type of agreement. If I guess the parties can reach any type of agreement they want. And so if the landlord doesn't want to restart the case all over again, then maybe they're willing to sort of give you some type of bonus. But if you're signing something or right where you're saying this is the truth and that's not the truth, then that's not legal.
Okay. And this may be, I don't know if you were able to answer this. Um, if there is a monetary judgment in a non-payment case and the tenant respondent moves out of state, in your experience, what is the likelihood that the landlord will ever collect the judgment? Does the state matter?
Great. So that's an important question. I'm going to go, um, let me just jump to types of judgments really quickly because I think this is important. So judgments can both be monetary and possessory. So a monetary judgment just means that you're acknowledging this is how much is owed and that the landlord can collect that money from you until it's all paid back. So in this case, what the tenant is saying is, let's say I signed a judgment, I said $5,000 was owed, I have to pay it by the end of April, and I decide, you know what? I'm moving out of state. I don't want to pay this money. I'm going to go live in Florida. You move to Florida, and the money doesn't just magically disappear. If you agree to a monetary judgment or a money judgment, you still owe that money. And the landlord can try to sue you to collect that money from you. And if you're working, the landlord can garnish that money or pull it out of your paycheck. So it's really important not to agree to a judgment if you don't agree with the amount that it says that you owe for whatever reason. So that's important. Um, and so the other thing that's also true, though, is it's not just the person who decides, I don't want to live here anymore, they relocate. It's also true if you get evicted. And I think this can be surprising to a lot of people that if they end up getting evicted over the case and they still didn't pay the money, the landlord can still try to collect that money from them. And if they're working, they're likely going to try to garnish their wages. So I think in the example here, how hard is it's hard, but it's not unheard of. At least in my experiences with tenants in the Bronx, I don't think many landlords are suing our clients if there's unpaid money in sort of civil court, but they can. So that's important, especially for working families. A possessory judgment, on the other hand, is you just saying, I give the landlord the ability to take back the apartment if I don't do X, Y, and Z. And in a non-payment case, that usually means if I don't pay the money by X date, then I can be evicted. So, and then I'm gonna jump ahead real, I'll come back to the other slides, but a final judgment is something that is both monetary and possessory. So that's usually what you're seeing in a non-payment case, right? It's both the acknowledgement, this is how much money is owed, and I must pay that money until all of it is paid off. But it also means that if I don't pay that money by X date, the landlord can also move forward with an eviction. And even if I get evicted, the landlord can still collect whatever the judgment amount was until all of it is paid off. So I hope that answers the question. Any questions about judgments? And then I do want to go back just to a few things.
No questions about judgments. I just forgot to ask this when we were talking about obtaining an attorney. If there is a warrant of eviction from the marshal, will it make it easier for a tenant to get an attorney?
No, no, unfortunately. Like I think no, and you don't want to sort of take that risk. It's I hate saying this. I hate saying this because I think that tenants have sort of been misled about how much assistance is available, like legal help is available. And and again, it's not fair. Like I just want to acknowledge that tenants should have the right to have an attorney help them through a very difficult process. And I wish that, all the legal services providers could do more. But the reality is like we are just at capacity, and it's very, very, very hard to get an attorney if you did not get one on that initial court date. So do not, I wouldn't try to sort of beat the system in some other way or sort of jeopardize, getting yourself closer to eviction, thinking that that might help. The reality is that like there are just so many emergency cases that it's really, really hard.
Are market rate tenants protected by the Tenant Safe Harbor Act?
Yep. There are two COVID specific defenses. So the first is the Tenant Safe Harbor Act. The Tenant Safe Harbor Act essentially means that tenants cannot be evicted for any rent that is owed between March 2020 and January 2022. So if the tenant can show I owe rent between any time period, any month for that time period, and they can also show that they experienced a financial hardship, then they cannot be evicted. The tenant still owes that money. So that's important to recognize. That money just doesn't disappear, it doesn't go away. It just means that if the tenant can't pay that, they can't be evicted. So just like a quick example, let's say a tenant owes rent between March 2020 until February 2022. The only month that they would have to pay to prevent their eviction would be February 2022 because it's outside of the Tenant Safe Harbor Act time period. They still owe all the other money, and the landlord can get the monetary judgment. So as we talked about, they have to pay it until it's paid off. If they don't pay it, the landlord can garnish their wages, for instance, but they can't be evicted for it. The other COVID defense is ERAP. So ERAP it stands for Emergency Rental Assistance Program. So during the pandemic, the federal government gave states money so that they could sort of help tenants who had fallen behind in rent during the pandemic. One of the protections from ERAP is essentially that the landlord cannot raise your rent for 1 year after the approval. So if the approval was issued in January 2022, the landlord cannot increase your rent until a year after that.
Somebody just wanted to know the Safe Harbor Act, is that for all tenants in New York City?
Oh, yes. It's for all tenants who experienced a financial hardship. And then with ERAP, the other protection is if you applied for ERAP and you were provisionally approved. So that essentially meant that that they reviewed your application, they thought you were eligible, but they needed the landlord to participate. If the landlord chose not to participate, then the landlord essentially cannot evict you for any of the money that ERAP would have paid. So if ERAP would have paid 5 months of back rent from 2022 and the landlord didn't participate, then the landlord can't also collect that money from you in housing court or evict you over it.
Somebody said the landlord raised the rent during the 1 year time frame. Can this detail assist the case in the tenant's favor?
Yes. They should not, they should, if there's been agreement to pay the money that included that additional amount, they should sort of get it undone or have the money reduced.
Somebody just wanted clarification on the time frame for the Safe Harbor Act. I believe it's March 20 to January 2022, right?
Correct. It's
Okay.
essentially mid-March to mid-January, but to keep it clear, I think March 2020 to January 2022.
Somebody says they were under the impression that the landlord can apply any rental payments to whatever month they want as relates to the Safe Harbor Act.
Uh, I think what I'm hearing them saying is if the tenant makes payments at any point, then they can say it's not covered by the Tenant Safe Harbor Act. So that's not true. For instance, if someone was approved for ERAP and they were covered for 12 months, so let's say all of 2021, then those payments must be applied to whatever ERAP said that money was for, which would be the 12 months of 2021. So, or if a tenant sends in a payment and specifically says that the payment is for April 2024, then the payment must be applied to April 2024.
Okay.
I'm going to go back to, so assuming there was a settlement of some type and you're trying to get rental assistance, the best resource right now is HRA. So HRA during the pandemic has now moved its application process virtually, which means you do not have to go into a local job center to apply for public assistance. You can apply online, you can apply on the phone, which is a really big change. This is the website. You can also download an app on your phone or a tablet. It's the Access HRA app, and you can apply online. And the type of assistance that you can get from HRA sort of depends on your household size and your current income. But the most common types of assistance that families can get is the most common is what people know as a one-shot deal. A one-shot deal is essentially an interest-free loan to pay back rental arrears. Tenants will have to show that there was an emergency reason why they fell behind in rent. So, whatever reason the tenant might have, maybe there was an increased medical cost, or maybe someone lost a job, or someone had to pay for funeral expenses, whatever it may have been. They also have to show that they actually owe rent, and they also have to show that they can afford to pay their rent moving forward. The other type of assistance that someone can apply for online is known as FEPS. So FEPS is a rental subsidy program for people who qualify for public assistance and who also have children in their household. So this is going to be relatively common for families who have sort of no income. Maybe there's no employment income, so they've applied for public assistance. They receive some type of public assistance, and there's a minor child in the household. They should be eligible for FEPS. FEPS is a program run by the state. So if you qualify, you should be able to get it. City FEPS is currently undergoing sort of a lot of, it should be expanding. Unfortunately, under the Adams administration, they're sort of not expanding city FEPS. So there's a lawsuit by legal services providers and tenants against the Adams administration so that they're forcing them to expand it. But city FEPS is a rental assistance program run by the city. And it's sort of meant to help families who are not covered by FEPS. So for instance, a family who maybe because of their income, they don't qualify for public assistance, but they have prior shelter history, or there's been some DV, or there's a veteran in the household, or they've been referred by APS, then they might be eligible for a city FEPS rental assistance program. And then again, if there's no income or very, 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 very limited income, the family might qualify for cash assistance and a shelter allowance. So when in doubt, always apply. And the process online can be fairly long, but I do think it's much shorter than going in person. And if you go in person, make sure that you're prepared to take in, sort of identification for everyone in the household, your lease, any documents that indicate how much is owed. The other thing I'll say is technically to apply for any of these rental assistance programs, you should only have to show that you're in arrears. You shouldn't actually need a housing court case to apply. But the reality is that because workers are so overwhelmed and they're receiving so many applications, that the applications that are currently being prioritized are for people in housing court. But you should apply regardless. And then lastly, if you're sort of also seeking assistance, you may want to go to your local home base. So home base locations are located throughout the city, and they essentially partner with HRA to assist with the one-shot applications or to provide other resources. Home base will go by different names in each of the boroughs. So for instance, in the Bronx, the home base locations are known as Catholic Charities, Bronx Works, and Help USA. You have to go to the home base location that corresponds to your specific zip code. So if you live in 10451, for instance, you may not have the same home base location as a friend who lives in 10463. So for you to find your local home base location, you can also just search home base HRA online and then click on your borough and look up the specific zip code. I will say our advocates at home base are very, 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 very overwhelmed. And there are very long waits, I think, to get appointments. So you want to go to the home base location as soon as possible to try to get rental assistance. And thank you to all of the home base advocates who are on the training today.
Somebody asked, what programs, if any, are people without documents eligible to receive benefits?
So when you say without documents, I'm assuming they mean based on immigration status. So there are many people who may not be citizens and who may not be residents who still might be entitled to some type of public assistance with HRA under some type of exception. So those exceptions might be someone who is here as an asylee or who is fleeing or who fled their country of origin based on some type of violence. So I think so HRA might be able to provide assistance. But if not, there are various charities and organizations throughout the city who can help. Some of them that I can think of may be Coalition for the Homeless, POTS in the Bronx, Met Council, those are a few of the charities that I can think of, but there are resources available to families who are undocumented. The other thing that is what I see most frequently is that even if the parents are not documented, they might have a child who is in fact a citizen. And that is very, very helpful because if the child is a citizen, then they might be eligible for public assistance. And if they are, then they might also be eligible for the rental subsidy. So if there are minor children in the household who are citizens or who have some type of legal status, then there's definitely going to be assistance for them.
I see another question here. It was directed to me, but I'll ask.
Sure.
Can a new landlord collect a monetary judgment from a previous landlord? The landlord has brought a non-payment case from a previous landlord. Hold on, let me see if I
No,
could. Yeah. It
sure.
says, okay, it says the previous landlord obtained a judgment. The new landlord is trying to collect it.
There's like it's like it's complicated, and the answer short is like maybe. So they'd have to get like substituted in for the name of the old landlord, and there has to be like a whole legal process through it, but not automatically. No.
Relating to ERAP, somebody said that NYCHA tenants is having a hard time getting their ERAP background because no one is sending the paperwork on their behalf at NYCHA.
Um, Tenants who were receiving some type of rental assistance, especially those who had vouchers, they were sort of the last people to have their applications processed. So for instance, I have a client who we applied back in 2020 and she just got an approval last week. And because she has a Section 8 voucher. So it took a really, really long time. So their applications will always be last. But if they're saying that the delay is happening because NYCHA is not submitting documents, there's a special process for people in NYCHA public housing. But if the tenant has a voucher and their landlord is not NYCHA, then that's different, and they should nudge their landlord to submit whatever paperwork they need to, um, if the application with ERAP is still pending.
Okay. And then, yeah, I think we can hold off on this question. Yeah.
Sure.
Thank you.
Repairs. Most of the people that I meet in housing court have some repairs that need to get done. And, I want to make very clear that the law is very clear that tenants should expect to live in a safe, well-maintained building that is free of vermin, leaks, and hazardous conditions. And I'm going to say the next thing twice because it's very important. Your landlord must rate repairs in the apartment, even if you owe rent. Again, your landlord must make repairs in the apartment if you owe rent. I say this for two reasons. There are the clients who I meet who will say, I feel like I can't ask for repairs in my apartment right now because I owe rent, and I don't think it's fair. To them, I say, the landlord legally has to fix conditions in the apartment, even if you owe rent. And that's really important. And there is no condition that is too big or too small. So I don't care if it's like the paint in the bathroom is chipping or if there's a leak, mice, cockroaches, any little thing that needs to be repaired should be listed. So I usually encourage tenants that before they're going to housing court that they go room by room and write down all the conditions that need to get repaired. If you ask someone off the top of their head, they might give you 5 conditions and they completely forgot about the other 5. So I think it's really helpful to have a tenant walk through their apartment for you to sort of list all the conditions that need to get repaired. The other reason I say this is because there are many landlords or landlords attorneys in housing court who will say, if you do not agree to pay money today, then I will not do repairs. They can say that because they can say whatever they want, but it's not legally true. The landlord cannot choose to refuse to make repairs in your apartment simply because you are back in rent. So if there are conditions in your apartment that need to be repaired, you have every right to ask the judge like to speak with the judge and say, I don't want to enter into an agreement today because there are repairs that need to get done in my apartment. The other thing that is also true is simply because there isn't a violation does not mean that the landlord does not have to fix it. Violations help because they confirm to the court that, an inspector has gone out to the apartment and has verified that there is actually a condition, but it's not true that the landlord only has to fix violations. The landlord has to fix conditions if they exist, period. So that means that though it can be helpful to have official violations when you go to court, especially in a non-payment case. You can call 311 and report those conditions, but even easier is reporting those conditions online. So 311 has a website, and if you go to the website and you sort of click report a condition in the apartment, you can report conditions, and those automatically go to HPD. HPD will then come out to the apartment to do an inspection. When an HPD worker, again, like all city workers, I think everyone is really overwhelmed. So when an inspector comes to the apartment, they're not there to try to look for all the conditions in your apartment. They are sort of going to essentially go to whatever was reported and try to confirm whether it's true or not. So it's just really important that if an inspector is at your home, that you're also sort of walking them through to make sure that they actually see all the conditions that you're talking about.
Oh, somebody asks, what do you do about violations not being repaired after 311 and HP action?
So if there's been an agreement to do repairs and the landlord still isn't doing them, you can bring the case back to court and say that you shouldn't be forced to pay the rent until the conditions are fixed. Um, if the violations exist, like I know the frustration that is happening, but I would also encourage them to like keep calling 311 to report the violations over and over again. Sometimes HPD themselves might step in and do the repair, or the landlord might also be certifying that they've completed them when they actually haven't. So that might also be part of the issue.
So this leads to another question. Typically, how many order to show causes will a judge allow?
That's really hard, because I have seen some cases where judges will deny like the second order to show cause, and I have cases where we're on order to show cause number 10. So it's really hard to say. But what I will say about the order to show cause is you're filing an order to show cause in a non-payment case, the tenant is, usually because you need more time to pay rent. And you only file the order to show cause if there's a judgment. So again, this is a reminder about like why it's so important to try to settle the case without a judgment. Because once there is a judgment in place, it's that much closer to an eviction, and you really want to delay it for as long as possible. But that's a good point to sort of transition us to what an order to show cause is. An order to show cause is essentially an emergency motion or paperwork that you're filing with the court to try to stop the eviction or to resolve an outstanding issue in the case. So in non-payment case, tenants are usually filing an order to show cause to say, my payment deadline is April 25th. I don't have all the money. I want to put this eviction on hold. So they're seeking more time to pay the arrears. But you can also file an order to show cause as a tenant if the landlord said that they were going to do repairs and they didn't, or if you realize that there was a mistake maybe in the agreement, you settled for $10,000 and then you realize it was actually only 8,000, so you want to undo the agreement. Or if you missed a court date or you never received the court papers and the next thing you know is that you're getting a notice of eviction, maybe you want to go to court to undo that. But most frequently for tenants in non-payment cases, they're filing them because they want more time to pay the arrears. So, to answer the question about how many orders to show cause does someone get, the answer is like it varies because it's up to a judge. A judge makes the decision about whether they want to sign it or not. So different judges have different attitudes, and judges on different days might treat things differently. So it's always important that when you file an order to show cause and you're asking for more time to pay the arrears, that you take proof of what you're doing to try to resolve the case. So if that means that you may be scheduled an appointment with Homebase and that your Homebase appointment is on May 15th, you provide that letter, or that you went to Homebase last week and they referred you to apply for a one-shot deal and you already applied for your one-shot deal. Provide proof of those documents. It's also what judges also really want to see is that like you're paying your rent ongoing. So if you have made any payments since the last court date, you want to take proof of those payments with you to housing court. If the judge decides that they're not going to sign your order to show cause and they're going to allow the eviction to move forward, then the next step is that the tenant will receive a notice of eviction. A notice of eviction is a letter from the marshal indicating that they legally can move forward with the eviction. An eviction, so you can be evicted 14 days after the date of the notice of eviction. I want to clarify this because there are some people who say, I just received the notice yesterday. Why is my eviction scheduled for Friday? It's not the date that the tenant receives the notice. It's the date on the actual notice. So there might be many reasons. There might be a delay in the mail. Maybe the letter was lost, whatever it is. It's the date on the actual notice. And it's the 14th calendar day. That includes holidays and that includes weekends. So the tenant really should go to housing court as soon as possible to file an order to show cause if they think they need more time. If they have received a notice of eviction and they've tried putting the eviction on hold and the judge isn't putting the eviction on hold, they can generally call a city marshal at 4 o'clock the day before. And the notice will say the first possible date that you can be evicted is on X date. They should call the marshal the day before to see whether or not they've been scheduled. And if unfortunately they cannot, right, the judge isn't willing to put the eviction on hold and they're unable to stop the eviction, you want to make sure that you're sort of collecting important documents, IDs, medicine, change of clothes, so that you have that, because once the marshal goes, you will not be let back into the apartment unless you have permission from a judge.
This just reminds me, a lot of times when you're answering the petition, people tend to think that they have 10 business days to answer. If we can get clarification if it's 10 business days or 10 regular days.
It's 10 regular days, technically, but like the reality is for most people, landlords aren't trying to get default judgments until at least a month or two or even 3 after. So don't think that just because it's been more than 10 days, like more than 10 days, go to court, try to file the answer first.
And if someone asked, if someone is evicted, does the marshal also remove all their belongings and furniture?
Um, they can. So it's really, so if, yeah, if you've been evicted or there has been an eviction, a legal eviction, it is possible to still try to get back into the apartment. So if you can show that in a non-payment case, if you can show that you now have all of the money that was owed, you may be able to file the order to show cause, say, Judge, please put me back in. I now have all of the money that was owed and I can pay it over immediately. Or I just got an approval for FEPS or City FEPS or a one-shot deal. Please put me back in. So you may be able to get back in. I will just say though, if you have been evicted, the judge may also order you to pay legal and marshal fees in addition to all the rental arrears before you're put back into the apartment. So keep that in mind. Even though if you don't have an approval and you just need time to remove your belongings, you want to go to housing court as soon as possible to file the order to show cause, saying like, don't remove my belongings yet, or don't rent out the apartment to anybody else. Please give me an opportunity to collect my belongings and to remove them, and you may be able to do that. And lastly, so legal help for tenants. Again, you can call 311 at any point. So before a case has been commenced, while a case has been commenced, you can call 311 and ask for legal assistance. They should be able to connect you with a legal services provider to, at the very least, provide legal advice. So even if a legal services provider can't provide full representation, you should be able to obtain advice in some way, shape, or form. But as I mentioned, the best possible way to get an attorney to assist you with your housing court case is to request an attorney at that very, very, very first court appearance. Um, I meet many tenants throughout who have said, I didn't really think I needed one. I thought it was be straightforward. And the reality is, like, housing court should be much easier than it actually is. And it should be more accessible for tenants. But unfortunately, it's not, and having an attorney can be very beneficial. Many of the legal services providers have very great relationships with HRA and can advocate for speedier approvals or can help resolve issues that are going on. So I think it's usually beneficial to tenants to have an attorney in housing court. So if you want one, even if you're on the cusp and thinking maybe I do, just ask for one. You can always decide down the road that you don't want one, but it's going to be much harder to get an attorney if you don't get one on that first court date. And I think that's all I have. So thanks for joining us. I'm happy to stay on and answer questions.
Yeah, so I do have some couple of questions. So do I get, can someone explain the threat of plenary proceedings to be talked about? Because the mere filing of a case is permanent and pops up on Google.
Yep. So a plenary case means a case outside of housing court. So we talked about monetary judgments earlier. We said, that you will still have to pay that money until it's, you've paid it off. And then the landlord, right, even if let's say you owe $10,000, you say, I don't want to live here anymore. The conditions are really bad in my apartment. I'm just going to go. I found another place. I'm just going to leave. If you don't resolve the housing court case and you don't resolve the $10,000, the landlord can sue you in civil court, a plenary action to try to collect that money. So it is, and you may still have the same defenses. You might be able to explain there were conditions in my apartment, that's why I left, but the landlord can try to seek that money from you.
In your experience, is the typical NYPD officer aware that the landlord and or super cannot evict you from your home? Do they know what a marshal does? And then I don't know if you can bring this into discussion with the relevancy of the new laws that have just been passed.
Sure. So I do think that I shouldn't say that. I do think that law enforcement understands, or NYPD understands, that there is a legal process in place. That being said, though, and what I think that maybe this is hinting at is, like, if the landlord has illegally evicted a tenant, so there was no court date, there was no court case, they just changed the locks, NYPD can't restore you automatically. And so I think that that's important, because I think maybe that's what this question is hinting at. The tenant still has to start a case in housing court against their landlord to be put back into their apartment.
Do the police show up with the marshal?
No, generally speaking, no.
I do want to say the marshals have like a direct line to the police,
Mhm.
so just be careful about that. Um, can a landlord send you to arrears to collections without a court case? Can a landlord send your arrears to collections without a court case?
No, but we have seen or heard about sort of landlords reporting them immediately. But no, they're not supposed to.
Okay. What is damages arising from rent overcharge?
So if the landlord is overcharging you, so let's assume that legally they're only allowed to charge you $1,000, and instead they're charging you $12,000, you may be able to collect not only the extra $2,000 that they were charging you, but you can also get what's called treble damages, which would be an additional amount on top of the $200 that is owed. It's a legal term.
Somebody asks, do I, well, what are some of the legal aid attorneys in the Bronx and how can you get in touch with them? I think you explained it, but I don't know if there's like any other.
Sure. So I work with Bronx Legal Services. The other legal services providers are the Legal Aid Society, Bronx Defenders, MFJ, NICA. Uh, those are sort of the biggest ones that I can think of off the top of my head. Um, I will tell you, at least with my office, I can't speak for everyone else. The best possible way to get an attorney again is on that first court date. At the very least, you should be able to get advice. If you cannot, though, the other way that you can reach any of us is we all sort of rotate providing legal advice. So you can call the 311, ask for legal advice, and they will connect you with the legal services provider of the day to assist you.
Yeah, you can also call Housing Court's number and we will put that on the chat. Um, so that's another way. Um, can DHCR rent registration for a rental unit be subpoenaed by a court? The person has been unable to obtain their rent history.
Yes, you can submit a subpoena to get the rental history.
And then can a landlord start a holdover case with a month-to-month tenant without a lease and also demand rent arrears in the holdover case?
Um, if there is no lease and the landlord wants the tenant out, then yes, they're probably going to start the holdover case and they can. Their argument would be that we don't want to renew their lease, so we want them out. They, uh, in a holdover, what the landlord may seek is what's called use and occupancy. So, as I said, legally it's not called rent because rent means that there is still a lease in place. But if there is no lease in place and the landlord is but you're living in the apartment, you're using the apartment. So the landlord can try to collect what's called use and occupancy for the apartment. And they can do that in a holdover proceeding.
My question is, once I see a notice of petition of holdover is filed, but the client hasn't received it, is the client waiting for a date to appear in court? I think that's like a recent trend that we're seeing that.
Sure. In holdover cases, so in a holdover case, the court provides you with the first court date. The tenant does not need to go file an answer in housing court first. So in non-payment cases, the only way to get that first court date is for the tenant to go file an answer. Once they file an answer, the court will give them a court date. In a holdover case, the court will automatically give them a court date.
And then the last question we have is, do I get back the interest from my security deposit each year or when I give up the apartment?
I believe it's when you get the apartment or when you give up the apartment and you collect the deposit back, you should get the security interest.
Can a landlord charge you legal fees if you've never been to court?
No, unless there was some other legal action, but no.
Yeah. With the new laws that pass for good cause, can a rent stabilized tenant be easily evicted?
Good cause has there are already a lot of protections for rent stabilized tenants to sort of prevent their eviction. So for instance, tenants in rent stabilized apartments, there is already a good cause provision about them they can only be evicted either for non-payment of rent or for specific good causes. So the new good cause law doesn't really affect rent stabilized tenants in the same way.
Okay. So it is 4 p.m. So we will be ending here. Thank you so much, Fernando, for this amazing training. I think a lot of people got some clarification. And just to let everybody know, we will be posting our presentation along with the recording on our YouTube website and on our website, and we will put that information on the chat. But thank you, everybody. Thank you, Fernando, and have a great day and a great rest of the afternoon.